Good morning, everybody.
Good morning.
Good morning.
Wow, it is an amazing, gorgeous day here in Southern California. Um, what this is why we live here for days like
We
this.
don't mean to brag, but it's winter with 80 degrees. So just saying.
So anybody watching or listening from another state, yes, you want to live here. It's
That's
that
right.
hard thing. Once you get used to it, you can't stop. It's one of those things. So, well, good morning. Good morning. We are Landon Realty Group, and we are going to get started here, I think, rather quickly. Um, we are a local brokerage in Southern California, specializing in the LA and surrounding markets. We have a probate team that specializes in probates, and we have a great panel of agents here that we're going to discuss what the probate process is. If someone is not familiar with even what probate means, when a person passes away and without a will, or even if they do have a will, sometimes the estate is subject to going to probate, which is a court monitored system to dissolve the estate. And if they have a home, the home will get sold in probate. It is a process that is very specific. It's subject to court approval or court oversight. And so dealing with an agent that understands the process is very, very important. So let's get started. I am going to reduce my screen. Okay, so again, I think I just said that. Before we get into this, I want to just introduce myself one more time. I'm Jennifer Landon. I am the broker and owner of Landon Realty Group and have been selling and helping people buy and sell and invest in real estate since 1999. I also own a real estate appraisal company and a real estate investment company. And so the LA market and surrounding markets are our specialty here. And with us on the probate team, I will allow them to introduce themselves. We have Ivan Vasquez. You want to say a little bit about your experience as an agent and in probate?
You're a little muted, Ivan.
Oh, sorry about that. The dog was barking a little bit. I've been in probate and trust sales, conservatorships, partition sales for about three and a half years, from start to finish. So from getting the lead to converting it to working with them to establishing estate sales, everything that they need, all the way until escrow delivers them a check and the new buyers have keys. Um, it's a very technical process, a lot of legalities are involved. But over the years, I've learned kind of to deal with it, the ins and outs. So that's it. And now I'm here with one of the best brokerages that I've been blessed to be part of, the Landon Realty Group, with an amazing team, Nancy, and everybody else that just makes the work environment such a great place to work at.
I love that. Thank you, Ivan. And we love working with you. And Ivan is very humble. His experience is very deep, and he has knowledge that the average realtor doesn't. And so he's such a huge asset to our team. So thank you for being part of it, Ivan. And Miss Nancy Castillo is our marketing guru expert. This girl can take anything and make it look amazing without filter. She knows how to market a property. And why don't you give us a quick intro on yourself and what you do on the team?
They hired me for my looks, right? Because I make it look good. You can say that. Just kidding. So yeah, I am part of the probate team. I've been selling for a couple years now. I also have an appraisal background, so I know Southern California really well. And yeah, I am part of the probate team. I help everything. All the marketing materials look amazing. We definitely help you guys in strategizing and maximizing the best way possible in selling your home. So I'm very excited to be a part of this group. I was going to say that to second Jen. Ivan is very humble with his background. He has extensive knowledge in this, and so does Jen. So I'm excited to just be a part of the crew.
Wonderful. Now that you know who your experts are today on this panel, we're going to go into some of the details of what is a probate and what are the most important part of the process that you need to know in order to protect yourself as a trustee or administrator. And because let's face it, when you are faced with a probate, it is not a happy situation. Someone has passed in order to trigger the probate. So most people that are in the process, a majority, not all, have been related to the person, and they're grieving and confusing because it's emotional. So our job is to help guide you through that process and make sure that all of the technical things get done so you can focus on your family and healing and moving past that, moving past it so you can move on. Okay, so probate is a court proceeding to determine the authenticity or validity of a will. Probate is required when a house or other real property, bank accounts or assets such as stocks, bonds, mutual funds, brokerage accounts were not in a trust. If you have a trust, it shields it from probate. Also, the bank and investments accounts did not name a beneficiary. So if someone had an account with no one else on it and no beneficiary, the court has to determine who has the right to inherit that money, if at all. If they don't find someone, guess what? It does go back to the state. And finally, if another person did not own a house or a real property in joint tenancy with the deceased, who is the next logical person to inherit that property and have the right to inherit it. So a lot of it is just making sure that the right people inherit and are the beneficiaries of the estate. How much does probate cost? Ivan, do you want to go over this one?
Sure. Most people think that probate is not a big deal because they don't know all the costs that are associated with going to probate court. So this is just really the initial cost. This doesn't include any attorney fees, any realtor fees, nothing. This is just straight up to file your petition at the court. So you have to pay $465 filing fee to open the estate at the court, and then you have to pay $200 or to $1,200 to run a legal notice. So that's basically you're putting an ad on the newspaper that, hey, my deceased father, my late father passed. Any creditors here's I'm announcing his death. If he owed you money, come collect at the court. So that's one. And then there's another 465 interim fee to sell real estate with court approval. So even to sell, you need to pay the court for them to allow you to do that. There is also a $75 to $1,000 appraisal fee or more, depending on the size of the estate. If it's a large home or a small home, you can count on paying an appraiser to go out there and charge you some money just to tell you how much it's worth. And then once you're done with all of that, there is a $465 filing fee to close the estate at the court. So you're not done paying the court until the very end. And basically, just a rough estimate, it takes about $1,500 immediately to start the process.
And this is if you try to do it yourself. If you have attorneys, there are attorney fees in addition, correct?
Yes, and I believe that'll come up on.
Okay, excellent. So just understanding the basic cost is important. Do you want to finish up the fees with us, Ivan, since you started it?
So when you don't prepare your estate, you most likely will have to get an attorney just to make sure that the things that you file at the court are done correctly. And some of the statutory fees and commissions that personal representatives and attorneys entitled to are based on the following. So it's 4% of the first 100,000, then 3% of the next 100,000, 2% of the next 100,000 up to 800,000. If you want to go further in depth, I put the probate code for you guys to look it up. So just to give you a rough estimate as to what that translates to, An estate inventoried at 500,000 can incur $26,000 in statutory fees plus commission. So if the house is worth 500,000, you can easily expect to pay your attorney $26,000 in fees. And that's not including the realtor's commission if you do decide to sell the property because you can't afford to keep it or it's just not in your plans to keep the house. Very
Okay, so this is, but this is not the administrative fee. This is just a typical attorney or personal representative fee, correct?
Yes. And also, administrators sometimes get paid the same thing depending if they want to collect the fee. So you could be looking at whatever the $26,000 was times two because the attorney's going to get paid and so is the administrator handling the whole process of the sale. They're also going to get paid the same thing as the attorney. So it's a very, very costly process.
And the attorney's fee is set by law.
Yes.
So it's the same no matter which attorney you use.
Mhm. Definitely.
Yeah. Okay. So these are things that we don't want to overwhelm people. It's just good to know how people get paid, and typically they get paid through the liquidation of the assets at the end of all of this. That is correct, right, Ivan?
Yes.
Yeah. So this, other than maybe some of the filing fees up front, the cash out of pocket is limited, I believe, usually to those filing fees, if I'm not mistaken, and especially if you're doing the paperwork yourself, unless most attorneys, they would not require sometime, depending on the attorney, a retainer up front. Some would do it on a contingent basis, some may not, depending on, it probably depends on the liquidability of the estate, meaning
Right.
how much
You're
equity is in it.
absolutely right, Jen. Most attorneys, if they know that they're going to get a good buck for their services, they'll more often than not are likely to collect their fees towards the end. However, if they see that their margins are going to be a lot smaller, they usually like to collect their retainer fees up front and kind of a pay as you go process kind of thing.
Exactly, exactly. So now let's get into the steps to selling, because this, being that we are a brokerage, we deal with the side of probate that has to do with real property, the people that have to liquidate or want to sell the property. Most people do because they're inheriting a property a lot of times that is out of the area that they live in and is out of reach. So I mean, it's my experience 90% of the time, unless it's a spouse, for example, that is taking the property and living in it, it usually goes for sale.
You're absolutely right, Jen. You're right, 90% of the time, I would say. And even when it's a spouse, most of the time when you interview and you talk to these people, you find out they actually had a very interesting marriage, to say the least, with their spouse. And most of the time, even them, they have no emotional attachment to the property. So very high percentage of people that sell.
Yeah, it is. It's interesting. Okay, so let's talk about these steps in selling the property in probate. Nancy, do you want to go over the first step with everybody?
Sure. So first step is appointing someone. So the administrator or executor, as we call it, of the estate. In most cases, in a will, the decedents will name someone as the executor, for all their assets. And then if there is no executor, then the court will appoint someone to do this for them. So technically, the executor or administrator is the person who has the full authority to do what they can with the property and all the assets. You do have to be careful with this, because a lot of the times you want to make sure that you have, if it's children, it's multiple children. If it's just a spouse, then is it the spouse and the children? So you do have to know who is the executor or administrator for this. So the first step is finding out who is going to be the administrator or executor of the estate.
Now, typically, would this be named in a will, or would this, because sometimes an executor administrator is named. We have a case right now that an uncle or a brother passed away. He did not have a will, and so the family is in the process of trying to become named as administrator of the estate. And that process, the court would have to do their due diligence to confirm that the person that is wanting to do it is the most appropriate person for the family. Correct, Ivan?
Yeah, and just to add a little bit to that, when someone petitions to become the administrator of an estate, they actually have to have good credit, great income. They have to be bondable and insurable. So they do that so that that person who's now going to be in charge of the estate doesn't just, sell it off and then doesn't give anything to the beneficiaries who are entitled to a piece of that inheritance that deceased person left behind. So whoever is the executor is usually, like Jen said, the most appropriate person in all aspects of life, I guess, to handle this very, difficult situation, especially when you're dealing with property.
Exactly. And especially if it's going to be court appointed because it was not designated in a will. All right, let's go to the next point, Nancy.
I think you were on mute.
Oh, sorry. Nancy, do you want to go ahead and do the next step?
Oh, yeah, sorry. I was like, wait, what? So the executors, can you guys hear me? Sorry. Oh, I think it's, sorry, Annie, do you mind muting? Because I think we're hearing double. Sorry, we're all in the. As provided in the independent administration, the executor established the list price for the real property. The price takes into account the appraisal by the probate referee and is usually determined with the assistance of a real estate agent experienced in the probate and trust sale. That's us. The property is then listed for sale through the agent or the broker.
So just to add a little bit to what Nancy said, the probate referee, for those of you who don't know what a probate referee is, the court doesn't want the administrator of the estate to basically sell the property to their best friend for like a little money and then they have like a side deal. Like they want to prevent all of that. So they appoint a probate referee to go out and do a very, very basic drive-by of the house. They just go snap a picture and they come up with the value, and we have to come fairly close to that when it comes to negotiation. So I'll let Nancy handle the rest.
Oh, no, that's a good point. So it's just, and also I think another point that you make is, the referees really, sometimes they're not even like area savvy. It's something that we usually talk about too, right? It's just, it's just a quick, oh, this is what I think it's worth. One of the things that we talk about here is that not only is Jennifer Landon a certified and licensed appraisal, but she can help you in this in determining the appropriate price in the home, and that you're selling. So that's very important to know too. Agents market real property to the public aggressively as possible to attract the highest offer. This is generally involves a number of approaches, including signing, newspaper advertising, listing, real estate websites, hosting open houses, and so forth. Buyers of probate and trust real estate may be looking for a bargain. So the range of the offers are limited by the court. An accepted offer must be about 90% of or more of the probate referee's appraised value. So once a buyer is found, the real estate agent assists the seller in negotiating the terms that are satisfactory for both parties.
Yeah.
Do you want me to continue, Jen? When the property has accepted an offer, like the notice to propose action is mailed to all the heirs, simply stating the terms of the proposed sale. So the heirs have 15 days basically to review the notice to or pose any objections. If no objections, then the sale may proceed without the court hearing. I'm going to let you continue, Ivan.
Yeah. So just to give you guys a little more less legal terminology. So when you go to court and you're ready to sell, the administrator has to let all the beneficiaries know, hey, I'm going to sell the house. This is what we have an offer for. You guys have 15 days to either approve or petition against, against my action. So all beneficiaries have to agree to the administrator's price and the offer they got. If they don't agree, then based on the IAEA, which is a thing set up for executors, um, they can't sell. They cannot move forward if one of the beneficiaries objects to whatever price they're going to get or anything like that. So, um, yeah, so all beneficiaries have to agree. Otherwise, the sale cannot move forward. And then furthermore,
And
the,
go ahead.
the attorney for the estate applies for a court date, which confirms the hearing when the sale is to be executed. The court usually takes about 30 to 45 days from the date of the application was filed to have the hearing and to send all the notices of proposed actions to all interested parties and all that stuff. So it's a lengthy process. Even when you have an offer accepted, um, you still have to notice the beneficiaries. Make sure that the beneficiaries mail back the letter to the attorney within 15 days. Otherwise, they have to start the process all over again, and it can take some time. I've had instances where, the brother got appointed the administrator of the estate. Sisters were not happy with him selling it, so they objected every single time. And I think the sale lasted almost 2 years because the lady just was not budging, didn't want to talk to the brother. She was upset. So in probate, not only are you dealing with the court, not only are you dealing with realtors, attorneys, you're also dealing with your own family. And sometimes when the head of the household goes, or your loved ones that were in charge, it's kind of a free for all. It's a Wild West kind of world when no one's there to set any order, especially with family.
I agree. And I've had a couple of instances where I've had sisters disagree on how to dissolve the estate, given that there was multiple properties, and held up the whole process because they wound up going to court and suing each other until they could come to an agreement. It can be very lengthy and expensive, and more than anything, it can get very emotional, and it's hard. So we try to be the voice of reason, try to be the person that lays out bottom line, trying to keep things clean and moving along. And a lot of times, even in that instance, I wound up being the intermediator between the sisters to get the property sold. So we have a
I
very
was just
important.
gonna say that, Jen. You end up being, and that's something too that you want to have on your team, because you want to have people that can help and that can help mediate, because a lot of the times that's what it's gonna go with, and someone that can help you.
Correct. And not to scare anybody, all this is just information, because knowledge is power, and the more you're prepared, the less things tend to occur. But it's understanding the process and what can occur so you can be a step or two ahead of it and prepare for it. Because let's face it, a lot of us don't have to deal with these things. And when we're faced with them, it's brand new. I hope nobody has to go through this too many times in their lives, but as we progress and in life, we tend to encounter these situations more and more. So whether it's for a parent or a friend. So, all right, excellent. What's our next step? So we don't have to go into this in great deal as far as too much detail, but do we want to talk about the overbid process if there is a court confirmation hearing needed? Because most of the time, I would say typically court confirmation subject to overbid is not, it is less typical than the administrator just being granted authority to sell it. But in the instance, an overbid and court confirmation is applicable, Ivan, why don't you walk us through that process on how that works?
Sure. So when you, again, petition at the court to become the administrator, the court decides based on your, credit, income, insurability, bondability, and all those things, if they are just going to let you say, you know what, go sell it, we don't care, just pay us and you're all good, that's the easy one. Sometimes when court confirmation is required, it's because the administrator of the estate doesn't have everything in order. They may be missing a couple of things, but they are the next best person to handle the sale of the estate. And for these cases, the court wants to confirm the sale of the house. They want to supervise it. And when they supervise it, when the person gets an accepted offer, they schedule another court date after the notice of objection goes out. And then the judge gets all the offers, and the person whose offer we accepted still isn't guaranteed the house until the court announces to the public, hey, does anyone want to overbid the offer that they got? So there's like a quick little example of what that would mean. So a property listed at 200 that got an offer accepted at 175, the court sets the next overbid amount. So it's not like you can go, oh, well, I'm going to do 175, 100. No. You have to follow whatever the minimum overbid amount. So it's usually broken down 10% of the first $10,000 plus a 5% balance. So if you wanted to overbid on the house that for that example of 175, you would have to bid $18,425 above the 175. So this is kind of what Jen was saying. Most people, even if there is a court confirmation requirement, most of the time you don't get any people to show up because the next overbid amount is 18,000. So it's not really something investors do or anybody else does because the jump is pretty high.
Right. So, but the court has it there as a safety net in the off chance that the offer was too low and somebody would want to overbid, and also gives the family an opportunity if they wanted to bid on it as well. Sometimes someone in the family, it might mean something to them and they have a chance, that would be their last chance to purchase the home. So there's a couple of reasons why that happens. All right. And again, you don't have to remember any of this. We take care of all of this for our clients. And even if you're not in the area and you just have some questions and you hear this, see this video or listen to the podcast, reach out to us. We're happy to help clarify any of this information. All right, let's see our next step. So a couple of things on how to avoid probate in California. The reason that most people want to avoid probate is, as you've seen, it can be very expensive and it's very time intensive. So from start to finish, it can easily, with no snags, minimally take 6 months to a year if everything goes to plan. Given all the recent pandemic and people passing, the courts are very backed up. I can tell you, I personally know that even getting a death certificate is taking so much longer than it has in the past. So it's really a good thing to try to avoid probate in California if you have assets to protect and beneficiaries that are set to inherit. So one of the things you can do to avoid is to gift your assets before you die. I personally have a client whose father is 96 and mom is like 95, and they're starting to liquidate their assets and give them away to their children now, so they're not subject to probate and subject to all the taxation and the legal tie-ups. That's the way that they've decided to do it. You can also, your probate estate cannot consist of anything more than probate assets that you own at the time of that you pass away. So if you gift it all away, then there won't be anything to really have in probate. But then just understand that you will want to make sure that your correct beneficiaries receive them before you pass. Gift taxes do apply under certain circumstances if you do transfer them prior. So just realize that as well. You don't avoid taxation by giving them away prior to death. Another thing you can do is set up a living trust. This is probably the most popular way that people avoid probate. Setting up a living trust is a trust document containing all of your assets, the names of the trustees and beneficiaries, and instructions on how to manage it. And it has been drafted either by an attorney or a company that specializes in trust. And it has specific instructions on how things are to be liquidated and handled, and the court will always abide by the trust. Anything you want to say about the trust, Ivan?
It's probably the most cost efficient way to set up your estate planning, and it's cleaner. If for your loved ones that you have elderly parents, or just parents who are always out and about, that they're always out, so their chances of getting hurt or anything, the trust is just the best way to do it, because they will just lay out every single rule, contingencies. Like, I've had one where the person who passed away said that if any of his sons start arguing about, oh, why does he get that, or why does she get this, whoever gets an attorney will only get $1. Like, you can set up like your trust in a very unusual way, however you want, to avoid any kind of confrontation amongst your siblings. So that was one of the craziest trusts that I've seen. He said, if any of you start arguing, at the end, when all the assets are distributed, you're only going to get $1. If they lawyer up, or if they start, delaying everything, that's how he set it up. I mean, most parents like to say, I'm going to control my kids or the assets that I leave from the grave, and they can almost literally do that. So
he said, respect my decision. This is what you all get.
Yeah.
Just are the most efficient way. I wouldn't really recommend to gift everything because of the gift taxes. Setting it up in a trust with the correct attorneys or the correct company is the best way to do it. And if you have parents or family members or anyone that that owns a home, it should automatically be in a trust. Like, that should just, there's no other way to do it, unless you're married and have joint tenancy. But even then, both parents can pass at the same time. I've had instances where the parent didn't die, but they were doing some construction work, and I believe a sledgehammer fell on their head and it cracked their cranium. So they were in a vegetative state. And because he had a trust, he still remained in the house. His kids had to take care of him, because oftentimes we find that the parent who has, all of the assets, may become ill and stuff, and they just be like, okay, well, mom or dad are in a vegetative state, let's just sell off everything, we'll throw them in a convalescent home and call it a day. Trusts kind of can either allow you to do that easier, if that's what your loved ones or the people that wish to be done, or it can be like, no, you're going to, if you want these assets, you're going to have to take care of me. So
it gives you directives on what to do on those hard situations, and it does wind up protecting the assets of the estate from taxation from different ways. Again, we would have you defer to your CPA. Every situation is specific and different, but in the end, the trust is the best way to protect your assets and to save money in the time that it is needed. So yeah, very great examples. That's how to avoid probate in California. All right, let's go to the next slide. Another way you can avoid probate is joint ownership with the right of survivorship. This is a lot of married couples have this. The property would automatically revert to the person on title that after the passing. The property being subject to joint ownership automatically passes, and two people who jointly own a certain parcel of real estate, or a married couple, domestic partners, community property. Another one is revocable transfer on death deed. A revocable transfer on death deed It allows the owner of real property to deed property to one or more beneficiaries and thereby exempt that property from probate after owner dies. This would have to be a deed filed with the property. It's not, the trust can do the same thing and gives a bigger umbrella, but it is another way to do it. And then payable on death designations. You can add a payable on death designation on your bank accounts, and which is essentially a beneficiary that once you pass, they can claim the money. And then vehicles with transfer on death registration. This is for cars. If you designate a transfer on death beneficiary in your vehicle, it would get transferred. A lot of people do not always take these extra steps with their personal property. They buy a car, they don't even think about it. And then the property, if say passed, would still have to go through some of these processes. But if you had someone, I'll give you an example. When you have life insurance policy, we always designate who the beneficiary is. We would never designate no one. However, on other items that we have, personal property like cars and bank accounts, we usually don't designate a beneficiary. So those are other ways you can avoid probate and streamline the process. Or you can put it all together under a trust, either which way, especially if there's going to be multiple beneficiaries at different amounts. Doing the payable at death designation or transfer and death registration is probably not going to be as efficient because they won't be, it's harder to break down percentages, right, Ivan?
All these things are just extras, but like Jen and I and Nancy were saying, the trust is really the best way. All these things require so much work, so many things to be in order. Like you really have to consult with your with attorneys to make sure all these things are done correctly. This is not something I recommend the average person to take on themselves. And even with when you have an attorney, they have a team, and that team looks it over and over and over until it's right. So if you don't have a great team, attorneys, people like Jen, myself, and Nancy to, at least point you in the right direction of where you can get help, it's not something that I recommend anyone to try on their own. I did put the vehicles with the transfer there because people sometimes forget about their cars, and it just happened to be that grandpa had that really cool 1970 classic muscle car that's worth over 100 grand. Anything over $150,000 in California, it's going to go to probate. So that's kind of the last things we always think about is the cars. But you never know, it could be the grandson who says, you know what, I want grandpa's car, I don't think my aunt should keep it because he loved me more, whatever. It goes into dispute, so you want to avoid that.
Yes, it's all about avoiding losing the asset by fighting over it later. So, all right, anything else on our slides here? I think that's a wrap. So any final thoughts or any questions from our gallery that joined us today, our insights?
So I'm going to add real quick that most of this, all of this is definitely great information. We can definitely email it, talk to you guys about it. You just have to get in contact with us. Again, the probate process is not something that everybody deals with on an everyday basis. It is a difficult process emotionally and as well as with paperwork. So let professionals help you with that. We have experience in helping families, sell and really do this the right way. And we work with a various of referrals that can help you with it. CPAs, attorneys, estate sale planners, and, just let us help you, or at least, see that you can get professional help in your probate process.
And as you guys can see, probate is not the most fun thing to learn about. It's obviously nothing about, your walls or designing, a specific doorway. It's a very legal and, must I say, boring process, really. I wish I can, tell you guys, oh, probate is fun because you'll get to be a lawyer or you get to be, it's not fun. It's very painful at times. We've had occasions, actually just yesterday, Jen, Nancy, and myself were talking to some people that we're going to list their home, and the lady broke down in the middle of our presentation and started crying because it was so painful to have to talk about numbers and money and taxes and all this when probably the only thing that she really cared about was the death of her loved one. And we always try to be as sensitive as we can with those situations. However, ultimately, you know, legal decisions have to be made and responsibilities are high. So that's kind of where we really emphasize our focus on, is to be empathetic of everyone's circumstances and situations. But at the same time, we also focus on what needs to be done and avoid probate at all costs. Don't leave this to your loved ones. Like if you really want to give something to your loved ones, give them a trust. Like set all your assets the correct way. Because once you're gone or your parents are gone, that's when you really find out how your sister, your brother, or your aunt really felt about you or felt about you know.
We laugh, but it is true. And the last thing I will say, and both Nancy and Ivan said it so beautifully, is this is a very emotional time. And whether you were super close with your loved one or not, you're dealing with death of someone that was in your family or in your sphere. And these big decisions, it can be really hard. So we allow you to focus on what is most important emotionally in the healing and figuring out what you're going to do with everything. And we handle all of the details so you are secure and you have the certainty that we have your best interest and everything is okay and good on our end. So we free you up from all of that stress and allow you to focus on your family. So if you have any questions, even if you're not local to us here in the LA or greater area, please reach out anyways. You can find us at lrgla.com. We're in all the social media links at Landon Realty Group. My name's Jennifer Landon. This is Ivan Vasquez and Nancy Castillo. We're on all social media. Anything else, how they can find us, Nancy, that you can think of? Well,
we also are on Anchor. So if you want to send this over to someone that, we know work times, you can send it over and they can listen to it through the podcast, like Jen said. Mm-hmm. So listen to this and stay tuned for more. We have more episodes coming up.
Yep. Yeah. We'll constantly post as much information as we can to help you out, and feel free to email us or call us. Our toll-free number is 888-541-6650. 888-541-6650. And hope you have a beautiful day and look forward to talking to everybody again soon.